polite. Even from what Mira just said, and from all the controversy and all the discussion in the press that you read about this issue, you would think that ID requirements are pervasive throughout the United States. Actually, the truth is that almost half the states have very minimal voter ID requirements that apply to a very small number of voters. And these states actually report that they have no greater problems with voter fraud or any of these kinds of issues than any other state. Let me just briefly review for you the state ID laws that are in place. 18 states do require ID for all voters, but they allow for a wide range of both photo and non-photo ID identifications, including things like a paycheck, a personal check, a student ID, a Medicaid card, things like this, utility bill. 4 states request all voters show photo ID, but without the photo ID, they can simply fill out an affidavit on the spot at the polling place and cast a regular ballot. 2 states require ID from all first-time voters, but again, there's a wide range of ID that they can use when they come to the polling place. So the overwhelming majority of states have very lenient voter identification laws, and none of them report any more polling place fraud than any place else. Florida also requires photo identification, but it does not have to be government issued. And in addition, if you do not have the ID, you can vote a provisional ballot, which will then be reviewed by the Board of Elections and verified by them with the presumption that you are an eligible voter. So it's really only Georgia and Indiana that require a government-issued photo ID in order to vote. And in Georgia, it's much, much easier to get the so-called free ID that they all talk about than it is in Indiana. So let me then turn to the Indiana ID law and talk to you a little bit about why it's so contentious and so troubling. Indiana passed the most draconian, restrictive voter ID law in the country. It requires every voter to present a current photo identification issued by the state of Indiana or by the United States. If you don't have an ID with you, you don't vote, basically, period. I've made the rules that the Secretary of State has set forth for getting ID that you should have gotten on the table in the back, which should show you how incredibly daunting it is. Basically, if you don't have a current driver's license or a passport, you've got a lot of problems voting. In order to get the so-called free ID, which is supposedly the answer to all the problems, you have to go to a DMV during working hours and present a primary document, a secondary document, and a proof of residency, or 2 primary documents, or 1 proof of residency document. The only items that count as primary documents essentially are a original stamped birth certificate or a passport. Now, many people don't have an original birth certificate at home. I certainly don't myself, and only about 1/4 of Americans have passports. So the voter without a birth certificate then has to go out and buy a copy of their birth certificate, which costs in Indiana between $12 and $20, and a lot more if they were not born in Indiana. And in the ultimate catch-22, in order to get the birth certificate, they may have to present all sorts of other kinds of ID. So you're really in a troublesome situation in that case. And more troubling still is that in Indiana, under the Indiana law, there's absolutely no recourse if you don't have that ID. Unlike the other states that I mentioned where you can fill out an affidavit and then be able to cast a regular ballot, Indiana doesn't have any kind of backup measure like that. If the voter comes to the polls without the right kind of ID, at least the kind of ID that the poll worker thinks that they should have, they can't vote by regular ballot. Instead, they have to come back to the election offices within 10 days after the election and either present the suitable ID or sign an affidavit swearing to their indigency, which is completely undefined by the law, and they have to swear to that under a penalty of perjury. I should also note that there was a recent study that showed that about 10% of Indiana voters don't have the requisite ID for voting purposes, so that's the universe that you're talking about. Now, throughout the country, there has been a great deal of litigation about this, and although you might think that universally ID laws have been upheld by the courts, that also is not completely true. In Georgia, in the early rounds, the law was actually struck down, and the federal court initially suspended the requirements for the November 2006 election, but subsequently dismissed the case and allowed the ID requirement to go into effect. That litigation is still pending. The plaintiffs have appealed to the 11th Circuit. In Arizona, it was a less strict ID law in question. You could show 2 non-photo IDs. There, the Supreme Court overturned the 9th Circuit Court order enforcement of the law. The 9th Circuit Court have affirmed the denial of injunctive relief, and that, too, continues to be litigated at the trial level. In Albuquerque, New Mexico, they also passed a photo ID law just for that city. The trial court there struck down the ID provision, finding no evidence of fraud and therefore no important state interest that was furthered. The defendants there have appealed to the 10th Circuit. And in Missouri, their photo ID law was struck down by the state trial court, and then that was affirmed by the Missouri Supreme Court, with the court finding that the requirements imposed a severe burden and therefore there was no compelling state interest. Now, in none of the cases in which ID requirements were upheld were the states able to find a single case of polling place fraud that a voter identification requirement would have addressed. However, Republican-appointed judges have not required them to do so, applying what is at best a rational basis test to these laws. This includes Judge Posner in the 11th Circuit, who applied a very low level of scrutiny to the Indiana law and in fact held that although he conceded there were a number of people who would not be able to exercise their right to vote, there wouldn't be all that many of them, and therefore it's no big deal, it's constitutional, it's fine. It wasn't important to him the burden on an individual's right to vote, but rather how many people would be affected by the law. Let me just quote for you for a second from Judge Posner's opinion upholding the voter ID law. He said, even though it is exceedingly difficult to maneuver in today's America without a photo ID, try flying or even entering a tall building such as the courthouse in which we sit without one, and as a consequence the vast majority of adults have such identification, the Indiana law will deter some people from voting. A great many people who are eligible to vote don't bother to do so. Many do not register, and many who do register still don't vote or vote infrequently. The benefits of voting to the individual voter are elusive. A vote in a political election rarely has any instrumental value, since elections for political office at the state or federal level are never decided by just one vote. And even very slight costs in time or bother or out-of-pocket expense deter many people from voting, or at least from voting in elections they're not much interested in. So some people who have not bothered to obtain a photo ID will not bother to do so just to be allowed to vote, and a few who have a photo ID but forget to bring it to the polling place will say, what the hell, and not vote, rather than go home and get the ID and return to the polling place. No doubt most people who don't have photo ID are low on the economic ladder, and thus, if they do vote, are more likely to vote for Democratic than Republican candidates. He also found that it was no matter that there was no evidence of any kind of polling place fraud in Indiana because the state was free to impose the requirement based on just the hypothetical possibility of a future fraud. So this is what the case may then come down to. Whether the court agrees with this view of voting rights, finds the burden of the ID requirement is not severe, and hence does not require strict scrutiny. Then using the test employed under the Burdick case, which I'm sure we'll talk more about, which we can go into more detail, will they use a lower standard of scrutiny, and what will that standard be? And even if the Supreme Court agrees with Posner's approach to evaluating the burden, will they require the state to present any evidence that the law furthers the state's interest in preventing fraud? Courts to date have not been requiring the states to make such a showing at all in order to meet the constitutional test set out by the Burdick case.